Yes, I'm here.
All right, thank you, Mr. Burstein. And Mr. Arnett, are you here? Or Ms. Arnett, are you here? Either one. Ms. Arnett, go ahead and take
Yes,
yourself
Diane
off.
Arnett, I'm here.
Thank you very much. All right, is Damon Arnett here? Or
Damon
he is
Arnett
not?
is deceased. Is
Okay,
a
well then, okay. All right, thank you. I just want to do that. All right, so y'all are the two parties. And as much as I understand that other people may want to be talking for the parties, they can't do so. This is really between the parties. This is not, as far as I can tell, a multi-unit entity, and it's also not a corporation that owns it. It's Mr. Burnett. So this is a de novo appeal, I said Burnett, Mr. Burstein. Mr. Burstein and Ms. Arnett, y'all are both here, and it's a de novo appeal. I note that there was 1850 put in the registry of the court as of October 8th. And we're ready to proceed. Let me go ahead and give you the way this works. Plaintiff can give an opening statement, very brief summary of the facts as they perceive them. Then the defendant may give an opening statement as well. Sometimes people just waive it and they just want to go straight into their evidence. I'll just remind you that this is a court of record. We've got a court reporter, so it's not like you were in JP court anymore. So, you know, that phrase in The Wizard of Oz, Dorothy, you're not in Kansas anymore, kind of the same thing. So I need for y'all to understand that this is a court of record. And because y'all are both pro se litigants, y'all are going to have to still follow the rules of evidence and the presentation order that I provide to you. I'm not here to teach you the law, nor am I here to instruct you on how to present your case. Even if you have other witnesses here, they can't run the case. It's got to be the parties that run the case and do the presentation. Okay. Unless they have a lawyer, and that's something different. All right. With that being said, Mr. Burstein, you and Ms. Arnett may have opening statements, or do you wish to waive that and go straight into testimony?
I can have a open statement, but I have my broker, the property management, Aaron, with me. No?
He's there and he can be a
Yeah.
witness, but he cannot run this matter for you. He cannot represent
Okay.
you as a lawyer in this case, which is what he would be doing if you're having him ask the questions and run your case. It's up to you to do that. Okay.
Okay. So
So would you
basically,
like to hold on? Would you like to give an opening statement?
yes.
All right, so let me go ahead and swear you in and Ms. Burstein in, Mr. Matagi, I'm sorry, and Ms. Arnett. Please raise your right hands. Do you solemnly swear affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes. I
All
do.
right, I noticed that Ms. Burstein did not raise her hand, so she must not be testifying. Oh, now her hand's up. So all right,
Yes,
and Ms. Arnett, I caught you
yes.
already, and I caught Mr. Montague, but I hadn't got Ms. Percy now. I said, yes, that's her hand raised, and yes, she will testify truthfully, et cetera. And Ms. Percy, I don't have you on video, but I'm going to assume you're going to represent to me that you did.
Yes, I did. I
Okay,
did raise my hand.
okay, very good. Thank you very much. All right, so, and I understand this is on 9107 Sanger. Is that right?
Yes.
And it's actually a duplex. Is
Yes.
that right? Okay. And do you own both duplexes individually, or how are they owned?
Yes. Yes. We both own it. Yeah.
Okay. All right. That's good to know. All right. With that being said, sir, you may begin with just a brief
Okay.
opening statement, just kind of what we
Oh,
got going on here.
okay. So original lease expired on June 30th. The tenant asked to extend it, and we extended until July 30th. And then she said to us, she want to stay a little bit longer, and we let her. I think she paid up to mid-August, and from that point she stopped paying, and we haven't got any income, and we had expenses during this time. So
Okay.
this is where we are.
All right. Thank you, sir. Ms. Arnett, do you have an opening statement?
Yes. So I don't know if I'm supposed to, it's an opening statement or a defense at this time. or-
Just an overview. I don't need all the
Okay.
specifics. He didn't either. He didn't tell me everything. It's just kind of a quick summary of what you think you're gonna need, what you
Right,
intend
like I
to
mentioned
present.
that Damon Arnett had been, is deceased. He passed away, at the end of June. And, so that is why I needed, that was the reason for the holdover. I did work directly with the agent, Morris Green Properties, to pay, prorated rent and any utilities that were owed. And I was paid through August, and the eviction suit was filed sooner than it should have based on the prorated rent is my overview, my opening statement.
Okay. All right. Thank you very much. All right. That being said, Mr. Burstein, you may call your first witness.
Okay, I'm calling Aaron Montgomery. He's the property management.
All right. Mr. Montague, you've been called to testify. You've already been sworn. Mr. Burstein, you can go and start asking questions of Mr. Montague.
Yeah. Aaron, so can you give a summary of if from the point that she stopped paying and how much she owed us and what
Yeah,
have we done?
the lease was scheduled to end at the end of June. Prior to that, in the middle of May, we had issued Miss Arnett a notice of intent not to renew due to some issues leading up to the end of that lease. She failed to vacate at the end of June, requested an extension through June, which was granted by the owner. Then requested an extension through July, again granted by you, the owner. And going into August, it was assumed because Diane had informed us of such that Diane would be vacating the property and moving to another property. In fact, it was reported to us by the neighboring resident that Diane had purchased a pod and had begun loading things into the pod to prepare for her move. Sometime later, pod, sorry. Oh,
Mr. Burstein, do you have
sometime,
Mr. Burstein, do you have another question for Mr. Montague? No, I think he just muted
No,
himself.
I'm
So I
going to put
guess,
it on mute. Sorry.
okay. All right. So, Mr. Montague, continue as to what happened next.
sometime later, not exactly sure when, the pod vanished from the property, and we assumed that Miss Arnett had moved out as promised. I paid a visit to the property, found that there was nobody living in the property, that the utilities had been turned off, and assumed that she had gone, but this was during the course of the eviction trial. So we made,
Objection.
What's your legal objection?
Well, the
If you're just going to counter what he's saying, you can testify to that.
the utilities were
Ma'am,
turned off by them.
stop talking for a second.
Okay.
I said, if you have a controverting or just something that you want to say opposite of what he's saying, that's not a legal objection.
Okay.
And so you'll be able to testify here in a minute. What I'd suggest you do is go ahead and write notes down as to where you contest what he's saying. And then when it's your turn to testify, you can say, okay, witness said this, and this is my position, or this is what I say happened. Okay. But it's not an objection. Just say, I disagree with that. That's not how it works. Okay. All right. Thank you, ma'am. I appreciate it. Mr. Montague, please continue.
thank you. I think I got a little ahead of myself there because prior to visiting the property to confirm that she had indeed moved out, I received a rental verification form from another landlord in town that Diane, in fact, sent a separate email asking that I complete and return the rental verification form, which we did. We do know for a fact that Miss Arnett moved out. I don't know if she moved into the property for which we completed the rental verification form, but I've been to the property since about the middle of August, at least a dozen times. Utilities have been off. Nobody is living in the property. The truth of the matter is Miss Arnett has moved out, and as difficult as it is to say, she is a hoarder. and she has a house full of stuff that's what she's fighting for right now. She's not living in the home. Utilities are not on. She just doesn't know, I think, doesn't know what to do with her things. And the owner is stuck kind of carrying the bag until we can resolve this matter by way of possession.
Okay. Thank you very much. Any other questions, Mr. Burstein, from Mr. Montague?
No, thank you.
All right. Ms. Arnett, do you have any questions for Mr. Montague?
No, I do not.
All right. Mr. Montague, I have some questions. Was there a notice to evict in this matter?
There was a notice to vacate that was originally sent to her on August 16th. And I have evidence available to the court right now to show you.
Well, that would be up to Mr. Burstein to make the offer, not you. So I'm going to let him. I've just simply asked if there was a notice to vacate or even a copy of the lease extensions, et cetera. And that's up to Mr. Burstein to mess with, not you. He can try to prove that up through himself or anybody he likes to, but you can't just simply say you're going to present it. So, Ms. Burstein, do you have any questions? Any other questions for Mr. Montague based on my questions, or are you done with this witness?
No, I don't have any questions.
All right, thank you. All right, Mr. Montague, you are off the theoretical or digital witness stand as we do this. Mr. Burstein, do you have any other witnesses you'd like to present?
No.
And you're not calling yourself to testify?
Basically, Morris Green are the one that managed this property. I wasn't there. I didn't try to get in as long as I know that the tenant is there. I didn't went there. I didn't went to visit there.
I see. And are there any documents you wish to offer in evidence?
I don't have any document right now, but we have, Morris Green have the letter that that.
Well, you have Mr. Montague here if you wish to do that. But like I said, I'm not doing it for you. So,
Aaron, can you present the court with the notice of eviction or any? I don't know what it's allowed. It's okay for me to ask him for that.
What did you just ask him to present?
I'm saying the notice of eviction.
All right. So Mr. Montague, Mr. Burstein is asking if you have a notice of eviction notice of eviction.
I do.
Or vacate. Has that been? That's already been downloaded to Box, has it not? Or has it? Did y'all download any documents into Box before we started this hearing?
I did not. No.
Okay. Well, then you just trying to show me your screen. It's not going to do anybody any good right now. Here's what I'm going to do. It's 3:27. I'm going to go into recess until 3:45, and y'all can both Ms. Arnett and Mr. Burstein may handle whatever documents that he sees fit to download to Box. Now, let me go off the record and as an aside, Ms. Arnett, it sounds to me as if you agree that you don't inhabit that property any longer since August.
August 20th, I paid prorated rent through September 3rd.
Okay, I'm not asking for a big detail.
Okay.
My question though is, you don't reside there any longer, right?
I don't. I'm trying to get my items out.
And all your items are still on the property.
Yes.
Since August to today. Right?
Yes. And
okay.
Yes.
And so those haven't been removed. You haven't paid rent, and you want to get that stuff out, I'm sure, and you don't want to be obligated for any more rent once that stuff is moved. So while we're on this break until 3:45, I suggest you talk to Mr. Burstein and Ms. Burstein about trying to resolve this, because it's pretty clear to the court right now that there are items in the property that haven't been removed and rent hasn't been paid. Okay, so y'all talk about it.
He
And if you're,
has been.
hold on,
has-
you're not listening to me, ma'am. You're not listening to me, and I'm asking you to listen to me. Talk to them and see what happened between September through November. If payments haven't been made, y'all really need to be talking about resolving this before I hear any more of this. Okay? That's all I'm telling you. You don't have to resolve anything. And I can hear the rest of this. Stop talking, ma'am. Okay? That's not how this works.
Fine. I'd unfriend you. That's not how it works. That's not how any of this works.
I'm asking you to talk to them. If you don't want to talk to them, absolutely fine. I'm just giving you an option to do that now. Okay? All right. If you don't want to talk to them, don't talk to them. But I'm going to go into recess until 3:45. Y'all download any documents you think you need to, end up offering into evidence, but it's got to be Mr. Burstein. It cannot be Mr. Montague. And Miss Arnett, obviously, you're going to do it yourself if you're going to offer anything. But please consider talking to one another before I take the bench back at 3:45. But like I said, you don't have to do anything. You don't have to explain anything to me right now. You can testify, get on the record, and then I'll make a decision based on what y'all testify and what you prove up. Okay, thank you.
Well,
Mr. Bernstein, I'm going to send you a message right now for you to tell me what your email address is. And the time is kind of the essence. So I think I'd prefer if you just email me your exhibit so that I can go ahead and download the stuff to Box. So otherwise it may take a little bit longer. So Miss Arnett, I think I have your email address, so I'll reach out to you. You should have my email address from when I sent you the Zoom link and everything. If you do have any exhibits, please send them to me as soon as possible, preferably in a PDF format. Mr. Bernstein, I'll send you my email address in a chat message so that you can send me anything that you are intending to offer. Okay.
Okay.
can you still hear me?
Yes.
Maybe we just hang out here on the call for a minute, and talk this through. So,
Here, I can put
I
you
wa-
in a breakout. I can put you all in a breakout room so you can talk amongst yourselves outside of the.
thank you.
All right, even though both parties hadn't done what I asked even before the trial started, hopefully now y'all have at least attempted to do this and done it correctly. Plaintiff is still presenting their case in chief. Mr. Burstein, is there someone you want to present and what documents you wish to identify and offer in evidence?
Yes, I just sent the document. Can I have Aaron present which document we're talking about?
You cannot have him do it. You can ask him questions
Yeah,
and then you
yeah.
can offer it. But no,
Okay,
he cannot
sorry.
just suddenly, you can't just say, hey, just prove everything up for me. That's not how this works.
Okay. Aaron, can you present the document that we send them?
Okay, that's not going to do it. You're going to have to identify
Okay.
what document you wish to offer into evidence, have him identify it, and then make the offer into evidence. Miss
Okay.
Arnett will have an
Okay,
opportunity. She'll have an opportunity to make any legal objection if she knows what the objection might be. She may agree to the exhibits. I have no idea. And Ms. Burstein's raised her hand up, but you're not a party to the litigation, so you're not going to be able to ask me anything. You're going to have to let Mr. Burstein do everything, and he's going to have to do it on his own. He can use a sponsoring witness, but he's got to be able to do it step by step. Okay. So I'm doing exactly what I told you all I would not do, which was tell you how to do this, but my patience with all of you is at a very low point right now because y'all haven't done what I asked you to do. So let's get going. Mr. Burstein, is there a document you wish to
Yes.
present with Mr. Montague and have him look at it and have him identify it and everything else?
Yeah, so I send the notice of a termination right of occupancy that been sent to Diane on August 14, 24.
Okay, hold on just a second. Let's see what the title of the document is and see if we can find it. If y'all somehow got it filed through my staff perhaps and made them do extra work. Let me look and see if we can find this. Ms. Colton, okay, it's in the box. Let's see. All right, Ms. Colton, I'm looking at, I don't see the case number on the list that I have. Maybe I need to try it again.
Yeah, maybe just refresh since I just made the
Yeah,
folder.
there it is. Okay. All right. All right, Ms. Burstein, which document? What's it titled?
The notice a termination right of occupancy.
All right. All right. You are free to ask Mr. Montague about that. Again, and I presume this is
Yes.
plaintiff's exhibit. What
Uh,
number is this? All right, we'll just, it says notice on it, notice terminating right of occupancy. All right. Go ahead and ask questions.
You want me to show you which other property?
Yeah, go ahead
Ooh.
and show the item that you intend to show to Mr. Burstein, to Ms. Montague about what you're seeking.
Okay.
Offering in evidence.
Aaron, can you can you tell when did we send Diane this document?
Ms. Montague, you're on mute, and also Mr. Burstein hasn't shared his screen or identified the document necessarily. I can't put up the document for you. You have to actually identify it. I can't telegraph to you what you're trying to prove up.
I have the document that was uploaded to Box, if I may share my screen.
Sure.
Okay. This is the notice terminating right of occupancy that was issued in August.
You're going to need to enlarge your screen, sir. Thank you.
Oh,
If you can. There should be a plus and minus thing on that.
okay.
There we go.
This is the document. This was.
Okay, let's let him ask you questions now, Mr. Montague.
Okay.
This person, you got any questions so he can identify what the document is?
Hey, Aaron, can you?
I'm going to shut
Can
this
you-
down pretty quick if y'all can't move this along.
I didn't, it's a. I can identify the document. That is a notice of termination to the right of occupancy. There's nothing. I don't understand what else I can tell about this document that other than the fact that we sent her on August 14, and she's still in the property, and she haven't paid.
Are you asking Mr. Montague if he sent this document to the defendant?
Yeah. Can you send
That's
it
your
to the defender?
question?
Aaron, can
Mr.
you send the
Montague, did you
document?
send this document to the defendant?
Yes, I did.
Thank you. Is it a notice is it a notice terminating occupancy?
It is.
And was rent due at the time?
It was.
How much rent was due at that time?
At the time the document was issued, the exact amount of the rent was $733.58.
What's the date of the document, sir?
August 14th.
All right. Mr. Bernstein, are you trying to offer this into evidence? Exhibit 1?
Yes.
All right. Is there any objection to Exhibit 1, Ms. Arnett?
I don't object, but I have my own documents to
Okay,
present.
no, that'll be super. And if we ever get to you, we will let you offer those in evidence. Plaintiff's Exhibit 1 is admitted. Thank you. Ms. Arnett, you can put yourself back on mute. I'm sorry to interrupt you there. All right, Plaintiff's Exhibit 1 is admitted, so that was on August 14th. Anything else, Mr. Burstein, that you are trying to get Mr. Montague to confirm? Offer?
Yes, we have the letter of the total amount, unpaid amount, since the last payment that Diane made until today.
And how is that document titled?
It's tenant letter Diane.
All right, so we'll label that
Yes.
exhibit number 2. And who generated that document, sir?
Morris Green. Aaron is the one of
Okay,
Morris
why
Green.
don't you have him talk about that and confirm all that?
Aaron, can you talk about the document?
Yes, the document shows the entire historical pay history for this lease, up to and including when she stopped paying rent in August.
All right. And you're offering that in evidence, Mr. Burstein?
Yes.
Any objection, Ms. Arnett?
May I ask the witness if my payments on August 14th and August 20th?
You'll have a chance to cross-examine him, okay?
Okay.
I just need to know about the
Sorry.
authenticity of the document. That's
It's,
okay.
yes, it's authentic. I just can't
Okay.
read it. I can't
Okay.
read it, but it looks authentic.
Okay. Plaintiff's Exhibit 2 is admitted. Anything else, Mr. Burstein, or is that it?
Yes, we have the proof of delivery for the certified letter that been delivered on August 19.
Okay,
For the
All right, any objection to that, Ms. Arnett?
I don't see the proof of delivery. Could I see the
Okay.
exhibit? Okay. And what address was this delivered to? I'm sorry. I don't know.
9107 Sanger Drive.
Okay, the exhibit doesn't, I'm not trying to object, Your Honor. I'm just saying it doesn't have an address on it. Sorry.
Okay, no, that's fine. All right, Plaintiff's Exhibit 3 is admitted with the understanding that defendant has noted that there is no address on this exhibit. It simply states delivered August 19th at, and I'm turning my head, sorry, 4:09 p.m. All right, are there any other documents you wish to offer?
Yes.
What else?
MTP notice of landlord not to intend renewal that sent to Diane on May 13.
This is Exhibit 4. Mr. Burstein, is that a document you tendered to the defendant?
Yes.
Or Mr. Montague, is that the one that you tendered to the
It
defendant?
is. This particular document was tendered via email and hand delivered at the door. It was not mailed.
Okay. And I presume you're offering it in evidence, Miss. All right. Mr. Burstein?
Yes.
All right. Ms. Arnett, do you have any objection to the notice of intent not to renew document?
No, I do not.
All right, thank you, ma'am. Plaintiff's Exhibit 4 is admitted. All right, anything else from this
No.
witness?
No.
All right, Ms. Arnett, do you have any additional questions for Mr. Montague on these documents?
Only if we could zoom into the ledger to see the payments that I made before the eviction was filed. I have copies of the
You've already
receipts.
have it, so yeah, you can.
Okay.
You can go ahead and do that, or y'all can show that ledger, Mr. Montague, and well, Mr. Montague has it right there. It might just be easier.
Mr.
I can
Montague,
show it.
would you please zoom
The
into the ledger and would you please
Yep.
look for dates, August 14th and August 20th?
So I believe what you're referring to is this $900 payment that was reversed. So after the notice to vacate was issued, Diane attempted to make a $900 payment through our automated online system, and that payment was subsequently reversed on August 21st for NSF. And there have been no payments since that date.
Okay, can you that?
I can zoom in
All
to
right.
show you,
All right.
see if I can, right there is where the system reported that there was an NSF reversal for her attempt to pay, leaving her with the remaining balance of $733.58 at that time.
All right. Any other questions for this witness, Ms. Arnett?
No, ma'am. No, Your Honor.
It's all right. I look like a ma'am sometimes, especially when I'm wearing this ridiculous thing. All right. All right. Thank you very much. Ms. Bershon, are there any other witnesses you wish to present, or do you rest?
No,
All right.
Thank
No.
you.
All right. Thank you. Ms. Arnett, finally, we have an opportunity to hear you. So you may call any witnesses and present any evidence. And thankfully, I think they're all now in box. You may proceed, ma'am. You want to call yourself to testify?
Yes.
Okay, great. I'm not telling you to do that. I'm just asking if that's who you want to
Yes,
call.
I'd like to,
All
I'd
right.
like to
Perfect. All right.
present
All right.
my
Go ahead.
4 exhibits.
All right, thank you. So let's go to those, and they'll have some title on them, I assume. All right, so it's got some various dates on them. And so you can begin testifying in narrative form. You don't have to ask yourself any questions. You just go ahead and just tell the court what you know, and go through the documents as you see fit, and make your offer just as we tried to do with the plaintiffs.
Okay. So I have any good, sorry about this. Can you put the dog up, please? I have an exhibit of $909.99 paid from my debit card ending in 0052. I don't
Okay,
show
so
any.
okay, before you tell me what it is, can you've downloaded or you emailed some of these documents to my staff, and they've downloaded it to Box for you, and there are certain titles on these documents. So is this a document entitled
20th.
August 14th, 2024 payment receipt to Morris Green Properties?
Yes.
Is that the one you're talking about? All right, so we'll call
Yes.
that Defendant's Exhibit 1. All right. And this is, tell the court what that is then.
So that's a receipt for $308.33 paid on August 14th to through the Morris Green Properties app called Appfolio. And so that's the exhibit. That's the first exhibit that I'd like to present.
Okay, any objection, Mr. Burstein?
No,
All right, thank you. Defendant's Exhibit 1 is admitted.
Okay, and my second exhibit is should be titled August 20th, 2024 payment receipt to Morris Green Properties.
All right, we'll call that Defendant's Exhibit 2. And that's one showing 909.99 on 8/20/2024.
Yes.
All right, any objection?
no,
Thank you. Defendant's Exhibit 2 is admitted.
Okay, and my third exhibit is the August 27th, 2024 notice terminating right of occupancy.
Second. Oh, okay. Yeah, so that'll be Defendant's Exhibit 3, the notice to terminate. All right. Any objection to that document, Mr. Burstein?
No.
All right. And so that Defendant's Exhibit 3 is admitted.
My fourth exhibit is titled August 27th, 2024 eviction petition.
All right. Any objection to that? That's just part of the
No.
court documents. All right, thank you.
No.
Defendant's Exhibit 4 is admitted.
Okay, those are all my exhibits that I currently have.
Okay. All right. Now now that you've got all the exhibit parts done, you want to go ahead and start testifying and let us know what's going on here.
Okay, so my procedural defense is improper eviction based on a defective notice to vacate after I'd
Okay,
had.
you're doing a legal argument right now, and I just need for you to tell me the factual parts of anything that you.
Parts.
are-
Okay.
Yeah.
I'm just, so this is me presenting a timeline of prorated rent that was paid through August. And I don't know if I need to do the math.
Oh, you
for
go
the
ahead.
judge.
No,
Okay.
you might as well. It might be a good idea.
Well, so on August 20th, I paid $900 and to Morris Green Properties. The rent is $18.50 a month. There was 31 days in August. That comes to $59.68 per day. When you divide 900, what I paid, divided by the prorated rate per day of $59.68, that equals 15 days. From August 20th to September 3rd would be 15 days. And so my exhibits will show those receipts, and my exhibits will show that the eviction was filed on August 27th. So that the eviction it shows the timeline of an eviction being filed on August 27th versus September 3rd, for example, where I wasn't delinquent.
Okay. Anything else?
No,
That's
that's all I have to say about the exhibits.
Okay. Now, do you have anything else you wish to testify about, or is that it?
May I present a procedural defense at this time?
No, I'll let you do that in
Okay.
your closing. Okay, that'll be easier. I'm just trying to get the fact part done first, and you've given me your view on that. Ms. Bursey, do you have any questions of Ms. Arnett? You'll have to take yourself off mute, sir.
No, other than the evidence that Aaron presented, August 19 payment bounced back. So even that she showed that she have a receipt.
All right. Well, you're arguing with you're
Okay,
making an
sorry.
argument.
Okay.
Do you have any questions for her though?
No.
Okay. All right. Very good. Ms. Arnett, is there anything else, or do you rest? Aside from doing your closing.
I rest
Okay.
because I don't have it. I have evidence on my phone that has not been uploaded to Box about the payment. But since
Okay.
it's not an exhibit, I can present it this time.
Okay.
Then I close at this time. I mean, not
Okay.
close. I rest at this
Right.
time.
Okay.
Thank you, Your Honor.
All right. Thank you. All right. So both parties have rested, and so now we're ready for any closing arguments. Mr. Burstein, you may go first.
Yes. So so the last payment based on Diane, it's made on August 21st, and since then there was no payment. She still have a item in the property. She don't live there, but we still cannot take position until right now, and I need to pay. I have a lot of all the expenses that I need to pay to the bank, and taxes, and some of the utilities which I didn't include, and we we need to take a position to this house. We cannot just keep her all the item without paying the rent. So this is our argument. There's nothing else, that I can say about it.
All right. And as you're closing, what amount of past due rent are you claiming?
A second.
Not late fees, not utilities,
No.
just base rent. That's
No, base rent. Give me a second. It was on my email. Hold on. Hey, Aaron, can you? I don't see the email right now. Can you? You know what? Maybe on the.
he's not going to be able to talk to you.
Okay, so I'll
and
say.
feed
Give
you
me a
that.
sec. Can you give me a second? I'll find it.
I'm just gonna finish this and let her go proceed.
Yeah. So the total amount is $6,283 just for rent.
All right. Ms. Arnett, closing argument, and you can go procedural or whatever else you want to argue here, okay? You're on mute.
Okay, right, so, my procedural defense is the, improper eviction due to defective notice to vacate. The landlord did not provide me with, anything on August 24th, which would have been 3 days before the eviction, case was filed. The landlord's agent did agree to take that $900. I do have, evidence that I was not able to enter an exhibit at this time that the payment did go through. I've just verified that electronically from my bank record. So my understanding was that I had till September 3rd. The eviction notice is filed, based on the prorated rent. The eviction was filed too soon, without that 3-day notice. And I don't have any evidence of anything on the 24th. The plaintiff did not present anything, that notified me on August 24th that there would be an eviction filed on August 27th. So then at that point, I waited until the JP hearing, paid rent through the court. So the landlord he can apply for that rent money to be returned to him, through the court. I paid and then just waited now to, this is the first time I've been able to provide a defense in my closing, for what I think was an eviction filed improperly too soon, based on prorated rent in August.
And then the final statement is
My final statement that I didn't get to mention about the utilities was that the landlord interrupted utilities, while I was trying to move out, which presented a hardship. I had to get my children out of the property. It wasn't safe for them to be there. But I was paying rent to I was paying utilities to the city of Boston. The landlord or his agent interrupted
you are
utilities.
now testifying, and we're past
Sorry.
that part. Okay,
Okay,
so
okay,
that's
you don't have
okay.
to enter, but that was my one objection. I didn't get to
Okay.
when the witness mentioned utilities. I didn't get to
All right, well,
object
there's
to
okay,
that.
but
Sorry.
you didn't get object, but you did have an opportunity to testify about that when you were testifying, and you didn't. So we're not going to go through that again now.
I understand.
All right.
Thank you,
Evidence
Your
has
Honor.
been closed. All right, thank you very much. All right, Ms. Person, you have, because you're in the position of the plaintiff, you have the actual final say in the closing argument. So a rebuttal. Is there anything else?
No.
Okay.
Thank you.
All right. Thank you very much. Both parties have rested and they've closed. I'm going to have to take a look at the exhibits that y'all downloaded. The defendant's position is that that the termination was not done correctly, that the notices were not done correctly because the amounts weren't due at the time that the petition was filed. on August 14th. There is an exhibit indicating that 308.30 was paid on August 14th, but that doesn't matter as far as the day goes. It depends on when the actual notice was provided and if rent was due at that time. My understanding is that the remainder of the rent that would be due even through today isn't actually in payment in full, because you still have an obligation to pay as time goes forward each month of rent as the appeal goes forward. So I'm going to take a look at all these things. I'll take it under advisement. I don't want to do it. I don't want to make a decision this very instant because I want to actually look at what y'all have downloaded. Those of you that are landlords, you need to understand if you individually own a property that, as you now know, you have to run with it. And Mr. Montague will actually help you in doing that, I presume, as you go forward if you end up having to do this again. Ms. Arnett, I'm going to say that I looked at the amounts that are paid in the registry of the court. Those are not current as far as can I tell, but there's not a sworn motion either to ask for an immediate writ. So I'm not going to be considering that, and I won't consider a late one filed either. It does sound to me that the parties actually agree that the amounts in the registry should go to the plaintiff, and that's not a hard order for me to sign, but I need to kind of double back and see whether procedurally this was done correctly or not. Okay. And just to give the courtesies to you guys of all the work you've already done and spent this afternoon listening to all this, it'd be appropriate for me to at least spend a little more time on what y'all have spent time working on. Okay. So I promise that I'll get it done as quick as I can. I have a staff attorney who is super and a Duke Law grad. And so she's way skilled at doing this. And so I will confer with her here in a bit or tomorrow. And as I go through the documents, then I'll be able to convey to you my final decision. Okay. Remind me again, the monthly rent on this property was
1,850.
1,800. Okay, that makes sense. We got the amount in the registry. All right, very good.
That's correct.
Okay, all right. And Ms. Arnett, I need to confirm you have moved out, but you haven't moved the items in the property out.
I haven't because I haven't yet because
Okay.
I had to put the utilities back in my name after the landlord
Okay, well,
took them out of my name.
those items have not been removed. All right, I just need to know that. All right, thank y'all very much. You have a great and safe rest of the day. And
Thank
if I
you.
don't see you before the holidays, which you're done with me one way or the other, you'd have another court of appeals if you needed to go that way. But I will try to get that decision to you as soon as possible.
And
All right.
how it's gonna deliver an email or?
Y'all can look online.
Okay.
Okay. All right.
Thank you very much.
Fine. I'd unfriend you. That's not how it works. That's not how any of this works.
I know. I hate it too. The worst thing is when they don't render a verdict, but you know what? I gotcha. On the 26th of November, which was about a week after this hearing, 10 days, 12 days after the hearing, which was in favor of the plaintiff. It ordered that the defendant should vacate and remove all belongings from the premises no later than November 30th. So this came out on the 26th. Did she see it? How long did she see it? Because she didn't got much time to figure it out. She better get to packing. It was further ordered that the defendant owed $5,550 in unpaid rent. It granted the plaintiff the right to go call the sheriff and have her hauled out if she doesn't go willingly. That does leave him with the problem of getting rid of her things. And finally, it was ordered, adjudged, and decreed that the supersedis bond. Okay, that's what. So if she wants to appeal this, what she has to do is she has to provide the court with $1,850 bond. And she has to pay that each month in order to appeal. This is what they do in Texas for landlord-tenant cases so that the money's not just floating around out there or getting spent. The court is holding it in an escrow that will go to whoever prevails. Maybe she gets it back, maybe she doesn't, but you're not just going to live there for free. Legally, it was not a complicated case, but It was quite entertaining at certain points. So do me a favor, hit that like button, subscribe, leave me a comment. Make sure you include hashtag Meg if you haven't done so already, and you'll be entered into our prize drawings. Spread the word. The quicker we get those numbers up, the quicker I get these prizes out and off my desk. Everyone have a great day, and I'll see you tomorrow.